Thank you. It's just after 5. I'll call the meeting to order. I see that we have Committee Member McMillan and Committee Member Ladresse on joining us virtually today. So I'll keep an eye on your screen, but just when it comes to voting or when you have something to say, just raise your hand and we'll address you from there. So I'd like to start with the land acknowledgement statement and acknowledge with respect the history, spirituality, and culture of the Anishinaabeg, the people of the three fires known as Ojibwe, Odawa, and Potawatomi Nation, who have inhabited this land from time immemorial, and further give thanks to the Chippewas of Saugeen and the Chippewas of Nawash, now known as the Saugeen Ojibwe Nation, as the traditional keepers of this land. We also recognize the Métis and Inuit, whose ancestors shared this land and these waters. May we all, as treaty people, live with respect on this land and live in peace and friendship with all its diverse peoples. Okay, I'm going to ask that the agenda be approved as presented. Asking for a mover and a seconder. Moved by Committee Member Glenn, seconded by. Up to you. Committee Member, thank you very much. Seconded by Committee Member McMillan. All those in favor? Okay, the motion is carried. Committee Member Ladresse, we can't see you and I can't see your hand on the screen too. So I think when it comes to voting, you'll have to use your virtual hand option or your video and raise your hand on the screen. So can you hear us okay?
Hi, are you speaking to me?
Yes, perfect.
Sorry, yes, I was on mute and I did not have my audio set up correctly, so I'm good to go now. Sorry.
All right, very good. Thank you. So I'm going to ask for a declaration of pecuniary interest. Seeing none, I'll remind the members they can declare at any time if they need to. So the minutes of the previous meeting. I'm going to ask for a mover and a seconder that the minutes of the Committee of Adjustment meeting held on January 16th be approved. Moved by Committee Member Glenn, seconded by Committee Member Ladresse. All those in favor? Motion is carried. I'm also going to ask for a mover and a seconder that the minutes of the Committee of Adjustment meeting held on January 17th be approved. Looking for a mover and a seconder. Moved by Committee Member Ladresse, seconded by Committee Member Glenn. Any discussion? Call the vote. All those in favor? Opposed? That motion is carried. So for our first order of new business, we have a new application for the estate of Muriel McCrabb. This is a meeting of the Committee of Adjustment to consider the application for consent for the estate of Muriel McCrabb under Section 53 of the Planning Act regarding property located on Big Rock Road, Francis Drive, and Concession 14. Madam Secretary Treasurer, please go ahead with your review.
Thank you, Mr. Chair. There have been no requests for deferral or withdrawal of the application. Notice of this consent in accordance with Ontario Regulation 19796 made under the Planning Act was given on January 11th, 2023 by ordinary mail to all property owners within 120 meters of the property, which is subject to the application and to all the required agencies. Notice was also posted on the subject lands in the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of the decision of the committee in respect to this proposed consent may submit an appeal. And I'd like to defer to Agent Ron Davidson to present the application at this time.
Very well, thank you. The floor is yours, Mr. Davidson.
Thank you. Good evening. Is it possible to have a drawing put up on the screen? It was the site plan, and if it isn't possible, that's just fine. Oh, no, that's fine. I'm sorry. Maybe, do the committee members have a paper copy of the application or the severance?
We have it virtually.
Okay,
Yes.
okay. All right. No, I just thought it would help. So, so first of all, again, my name is Ron Davidson. I'm a planning consultant, and I'm representing the estate of Muriel McCrabb. Her nephew, Alan Spear, is here tonight with me to my left, and Alan's looking after the estate. So there are three properties, or at least that's what everybody had thought until not so long ago. If you take a look at the County of Grey GIS mapping, they still appear to be three separate parcels. They're taxed separately, so the average person would think, in fact, they are separate. And about 2 years ago, when the estate tried to sell what we're referring to as lot number 2 now, the lawyer found out kind of at the last second that they had merged on title. So he could not allow for the conveyance of one of those parcels to occur to another property. So that person who's been wanting to buy lot number 2 has been put on hold for a better part of a couple years now. So that's when I got involved, because the lots have to be recreated, if you will. And unfortunately, recreating lots, even though again they show up on the county GIS mapping as 3, and it looks like they're taxed separately, or they are taxed separately, it's not any easier than recreating, or pardon me, creating new lots today. It's still subject to the policies of the official plan and the provisions of the provincial policy statement, or the policies of the PBS, and the provisions of the zoning bylaw and the requirements of the Planning Act. So I had to go through that. Now, unfortunately for the estate, the county official plan has a couple different layers of constraints, if you will, that apply to this property. First of all, the lands are identified as a significant wetland. Oh, not that. Significant woodland, big difference. A significant woodland can have development take place on it if you can demonstrate that there's not going to be an impact on the function or feature of the significant woodland. So on that note, an ecologist was hired a couple of years ago and did most of the work this past summer, and identified a building envelope on each of the 3 parcels, lots 1, 2, and 3, of 1 acre in size. That's their recommendation, 1 acre. So those 3 building envelopes have been identified. And the recommendation of the ecologist was that development could take place as long as development again occurred within those 1 acre clearing areas. And secondly, that there's some other recommendations as well, but that the trees not be removed during bird nesting season. Anyway, so that was one study that was required. And then another thing on the county official plan, another constraint, is that this area is identified as a bedrock resource area, which is another term for, and I hate to say this out loud, but a potential gravel pit site. Now, so the policies of the official plan state that, well, consideration should be given to a gravel pit on these lands, albeit, that's probably not what anybody wants to hear, and that's certainly not what these people are proposing. But nevertheless, an engineer was hired to take a look at the feasibility of extracting that bedrock resource. And probably fortunately for everybody that has an interest in the property, it turns out that the engineer was saying there's absolutely no feasibility there whatsoever of taking bedrock off. One of the concerns, of course, is its proximity to many cottages and homes, and of course the lake itself. So that was another checkbox that had to be done, that study. As well, the county official plan identifies some of the lands around the lake as being karst. So the engineer was asked to do a karst study, which included test pitting to see if there was cracked bedrock or fissures. And he concluded that there were no karstic features existing on the site, which is good. So those 3 studies were done, and then we filed the applications. We have since learned that SON now would like an archaeologist to get involved. So we are dealing with SON, and there will be an archaeological assessment done as a condition of severance. So that'll have to be done before the deeds are stamped. So lots of work has gone into this. In addition to applying for two severances to create the 3 lots, we also had to apply to amend the zoning bylaw. The reason for the original reason for the rezoning was very minor. Lot number 1 is just a little bit undersized. It's 4,010 square meters, but the zoning bylaw requires 4,047 square meters. So we needed either a minor variance or a rezoning, and it was suggested we go through the rezoning process. That application for rezoning was looked at a public meeting here by council about 3 or 4 weeks ago, and ultimately approved by council last week. When the bylaw was drafted, not only did it recognize the slightly undersized lot size of lot number 1, but it also identified the building envelopes that the ecologist had recommended. So development will for sure happen only within those 3 development envelopes. So again, that bylaw was approved by council. So that leads us to tonight's application, which is for the 2 severances in order to create the 3 lots. I'll say just a couple more things, I guess, just regarding some of the concerns that were raised from the neighbors. Some of the comments, it was thought that there was going to be a subdivision on the property. No, there's not. No, this is it. This is the development. There's also, I think, some confusion there when I start talking about, having to look at it for a potential gravel pit, that there was in fact going to be a gravel pit proposed for the site. There's not a gravel pit proposed for the site. I think if council ever wanted to have a large public meeting and fill this place about 3 or 4 times over, they would advertise for a gravel pit around Francis Lake, but that's not what's being proposed. The last thing I'll say is it's worth noting that today, building permit could be issued for anywhere on the property. Now, of course, once the bylaw comes into effect, it was approved last week, it would limit it to those 3 specific building envelopes. But just to be clear, there could be a building constructed on the property. Building permit could, for example, be issued tomorrow, if so be it. I just wanted to make that clear. Mr. Chair, that's it for my presentation. Thank you.
Thank you, Mr. Davidson. So 4 people have registered with the clerk to comment on the application. Ron has already spoken, or Mr. Davidson has spoken. Angela Renault, would you like to speak to the application? Is Ms. Renault with us tonight?
Yes, I am.
Oh, sorry, you're on the screen. Pardon me.
We just are interested in what the proposal is on lot number 2. Hello?
We're just waiting for Mr. Davidson to approach them.
Yeah. So on lot number 2, there has been a building envelope identified by the ecologist where there would be no impact on the woodland. That building envelope has been identified again in the zoning bylaw amendment. It will allow for up to 1 acre of clearing. So there will be that property will be sold and a house will be put on it.
Building in a house.
That is correct.
Okay. And that will be sold to an individual.
Yes. Yeah. There's a party lined up, like I said during my discussion there, that someone's been wanting to buy it for about 2 years now.
2 years.
And just to clarify, severed lot 2 is the lot that backs immediately onto the existing residences? The very uneven shaped lot?
That is correct.
It's
Oh.
the backyard of the Francis Lake houses, cottages. Yes. Yeah, that's what we wanted to know.
Sorry, Madam Secretary Treasurer.
Mr. Chair, for the purposes of the minutes, could I have the speakers identify their names, please?
I'm Angela Renault.
And I'm her husband, Mark.
Thank you.
So where's the building envelope on the proposed lot 2, Mr. Davidson? Sure. Yeah. Not real official.
Mr. Chair, just for the benefit of everybody that may be attending the meeting virtually, the development envelopes are included on page 16 of the planning report that is appended to
Oh.
the agenda package.
Sorry, I didn't go far enough down. Got it. Thank you. Okay, Ms. Renault, is that all for your comments?
Yes, it is at this time.
Thank you. So next, Lisa Arnold, would you like to speak to the application?
Yes, yes, I would. I'm just going to reiterate how I felt at the last meeting, on further review of where the package is, and we've been up to our cottage since. The way our lot is situated, and the way the cottage is situated on the lot, basically, I guess we're going to be looking directly at this property. It's when we look out our back window, it's going to be we're looking directly at this property. I guess my question would be, what, if anything, can we do to create some privacy or minimize the effect on our enjoyment of our property?
Mr. Davidson.
Yeah, I might as well try to answer that. So the amount of land that can be cleared will be up to 1 acre, but it doesn't necessarily mean it's going to be 1 acre. I think the average, maybe I got to be careful here, but myself, I would clear in a nice location like this, I would clear enough land for my house, a gravel driveway, a septic system, and a well. Doesn't mean I would want to, nor would I care to remove a full 1 acre of land. Having said that, outside the building envelope, though, all those trees have to stay. So I think if I'm not sure exactly where the speaker's house is located, but there's probably a great chance that there'll still be a lot of undisturbed area between their house or their view when they're looking out their back deck toward this building site.
It looks to me like it runs about halfway. The property looks like it runs about halfway into our backyard, across our back of our property, and then it goes halfway across the property of the neighboring lot.
Okay. So, I mean, without having an aerial photograph here and trying to figure out exactly where the house is and to answer the question, yeah, we don't know yet exactly where on this 1 acre building envelope where the new building is going to be. But if there are trees on the back of the Arnold property, and the neighbor was kind enough to tell me that there are some trees, hopefully that helps. Like, I mean, it's not in anybody's best interest, that you just clear cut so you can look in the back or if you or the side. I mean, if they put it in a different location, you'd be looking at somebody else would be looking at it from a different angle.
Right. Okay, just wanted to be on the record for, just expressing my concern about it.
So presumably, looking at the building envelope, I would expect that the narrow piece will be the laneway, and then the house will be in the
Correct.
piece. So I can see that the building envelope is at the back of the two properties that are adjacent. So I don't know if it looks Yeah, looks like half, third. I'm not sure what it is. Yeah.
And the laneway is very, very close to, very close to the side of our property. I mean, relatively speaking.
Thank you, Ms. Arnold. Do you have any more comments for right now?
Nope, nothing else to say.
Elizabeth Gillis? Gillis? Yeah. Yes. Thank you.
Yeah, so anyway, you guys have been really good in helping us understand this every time I call. Is it Jennifer? Who I've talked to, which has been great. Yeah, so another consideration is why does that envelope, is it have to go behind? Because there's nothing else behind all these other properties that are on the not the lake side. So I know there's a bigger piece of property that's like a 16 acres, am I correct? And why wouldn't it be built onto just the regular Francis Road? And then you could have that forested area. Sorry.
I wasn't sleeping there. Yeah, this is just an area, sorry, this is an area where we did ask the intended purchasers where they would like to build, and they looked at the whole site and they felt that that was, I guess, the nicest part of the property. So on that note, all the studies were done to take a look at specifically that site.
And the other question I have is how big a home are they, or do they have any idea yet? Is it no? No plans. Okay. Okay. And the last thing you said about you could get a building permit. The last part you said of your thing, I didn't quite understand. Of course, this is all new language to me. So
That's a good question. So the property right now is, sorry, I've lost my place here. How it's zoned. Here we go. So the property has a couple different zones on it. So the bigger 100 acre, which we're calling lot 3, is zoned RU. That means residential. And then the other lot 2 and then the smaller lot 1 are zoned SR, which is shoreline residential. The zoning bylaw does allow for a house or a cottage, we call it a house, we don't use the term cottage, to be erected. So there would be nothing to stop someone from building a house right in the exact same spot as building envelope number 2, or up here, or along Concession Road 14, just one lot, or one building, because you can only build one house per lot. So they could today build right there.
there'll never be, and there will never be any further push for subsequent lots being built, especially on this one.
Here. I can't say ever. I don't represent the yeah.
The neighbors use the property.
Excuse me, Mr. Chair, just for the purposes of those attending virtually, they won't be able to hear if the discussion isn't into the microphones. Thank you.
Okay, thank you.
Yeah, I mean, just my own feeling on that is it would be very difficult. For example, for lot number 2, I can't imagine how. Gotta be careful here, because I don't want somebody to be back here in 2 or 3 years time with an application saying, "Well, I remember that planner with premature white hair saying." That's a joke there. Thanks for laughing. Saying there would never be lots here. I doubt it, based on the fact that it's all significant woodland, and that property really doesn't lend itself to really a whole lot of lot creation. But I don't want to mislead anybody.
Fair enough. Sorry, Mrs. Gillis, is that all for your comments right now? Yeah. So I have some questions, but I'm going to go to the committee first. Does committee have questions or comments about the application? Yes, committee member Ladresse.
Through you, the chair, I was just wondering if we could ask Jennifer a question. Is there a lot frontage requirement for this area?
Through your chair, so for shoreline residential zone, I believe the for an unserviced lot there is, and I believe it is 36 meters. And this property has 141 meters of frontage.
Okay.
Thank you.
Any other members? So I'll ask the question. It seems to me that the sticking point from the community would be the location of the building lot more than the severances. So I'll just ask. I mean, I believe in the right to property and where you want to build, and you're right. If we were taking this lot, you could build one lot everywhere, but you wouldn't be able to build three. And that's what with the severed application is for. Is there no appetite to build down near? I'm going to call that the north end. I guess is that the right off the road, or is that?
Yeah, fair question again, and I'm just repeating myself when I say that that question was asked before we did all these studies of the potential purchaser, and he or she picked this spot. So the environmental impact study was done, the CAR study was done, and I guess the aggregate study was done for the whole site. But those two specific studies were done specifically for the building envelope on lot number 2.
So, I mean, from a community, I'll use the wrong words. You planners would be better at this than I would be, but in terms of the symmetry, the access to the road, the fitting in with the sort of the community landscape, it would seem to me that the north end would be the better end. Madam Secretary Treasurer, yes, take me off the hook, make a comment, go for it.
I would just like to just bring to everyone's attention. So council did approve the development envelopes on the 8th through an amending bylaw. The other point I'd like to make is that there will be a development agreement, a consent agreement drafted to incorporate the mitigation measures of the environmental impact study. And with those measures, there are requirements to avoid any tree cutting within the defined period of time for the nesting and breeding season, as well as there's a requirement to retain the tree cover. So within that agreement, there could be a provision made where the tree removal doesn't occur, maybe a certain distance from the abutting property lines apart from the access through the driveway. And that would then give the neighbors a bit more privacy. That is, I believe, 131 meter envelope. It's 131, and I think by 30. So it is quite a deep development area. So there could be a condition included within that agreement if to help alleviate some of the concerns from the neighbors if the committee chooses.
Okay. I won't belabor this much more. I have two minds. I respect the owner's ability to seek a building lot and put it where they want. I also kind of feel for the existing landowners there, because there is a feeling about somebody building in your backyard, whether it's perceived or real. And even if it is 76 plus 100 meters, so 400 feet behind your house, it still feels very much behind your house. But I think if we are looking at this from an approval standpoint, I think it would be difficult for us to not approve this. Is that accurate?
The rationale for refusing an application should reflect the applicable policy. And as per the planning report, the proposal meets the applicable policy.
As you were saying, yes, I think in planning, wasn't it? Okay. Are there any more comments from committee members? Yeah, committee member Glenn.
Through you, Mr. Chairman, and this is more of a question for Mr. Davidson, and it goes on to what he said with regards to the environmental impact studies, that all of the studies were done to demonstrate that this building site was the site. Did the studies conclude that the rest of the parcel was undevelopable, or only that it demonstrated that this site was where the studies wouldn't impede development? There we go.
We got a short circuit here. So the study was done focusing on these building envelopes. The environmental impact study, would not have taken into account the whole close to 200 acres of land that would have cost, $100,000 in ecology fees. So they took a look at these sites in particular. But to answer your question, Mr. Glenn, I'm not for a second suggesting that the study couldn't have looked elsewhere and come up with a conclusion for a different part of the property. I don't want to mislead anybody that way.
So just to follow up, Mr. Chairman, as it relates to Lot 2, the environmental impact study looked only at this site for the 6+ acres that are there. It didn't look at other suitable areas on the 6 acres for a building site.
It would have looked at this like there's 3 sites. So lot number 2, it would have looked at it, and the requirements under the provincial policy statement would be 120 meter adjacent land. I'm not sure how much further they went out beyond that, but it did not take into account the entire, what we're calling in the 16-acre lot number 2. No.
Okay. Committee member Ladresse, is your hand up?
Yes, I guess through you, Mr. Chair, I just wanted to verify with Jennifer. The application that we're making a decision on is for the severances that were merged on title, presumably by, mistake or whatever happened. We're just reestablishing the legal titles of the lots that were at one time lot, correct? And we're not debating the building envelope.
Yeah, through your chair, that is correct.
All right, thank you.
Okay, if there are no further questions or comments, I will call for a vote on the motion. The recommendation is that it has been demonstrated that the proposed applications are consistent with the Provincial Policy Statement 2020, conform with the County Official Plan, and comply with the Township of Georgian Bluff Zoning Bylaw 2020-20. It is recommended that severance applications B24/22 and B25/22 for the estate of Muriel McCrabb be approved, subject to the following conditions: that a reference plan be completed and a copy filed with the municipal clerk, or an exemption from the reference plan be received from the Land Registry Office. 2, that pursuant with Section 53, Paragraph 42 of the Planning Act, the certificate of consent be affixed to the deed within 2 years of giving the notice of decision, or as specified in the Planning Act at the time of the deed stamping. Note that Section 53, Paragraph 43 of the Planning Act requires that the transaction approved by this consent must be carried out within 2 years of the issuance of the certificate, i.e. stamping of the deed. That the applicant pays the applicable consent certification fee at the time of the certification of the deeds. That the applicant pays 5% cash in lieu of parkland in accordance with the Planning Act. That the applicant enters into a consent agreement with the township to address the mitigation measures identified in the environmental impact study by Palmer dated September 2022, and the mitigation measures identified in the karst topography assessment by GM Blue Plan Engineering dated October 2022. that a zoning bylaw amendment be in force and effect to recognize the reduced minimum lot area of Lot 1 of 4,013 meters squared, where 4,047 meters squared is required by the shoreline residential zone, and that the owner shall undertake a Phase 1 archaeological study or archaeological assessment and apply any necessary mitigation measures to protect archaeological resources to the satisfaction of the Saugeen Ojibwe Nation and the township. I'm going to ask for a mover and a seconder. Moved by Committee Member Glenn, seconded by Committee Member Ladresse. Is there any further discussion? I'll call for the vote. All those in favor? The motion is carried. I now call for an adjournment of this hearing. We need a mover and a seconder? Yep. Mover, Committee Member Glenn, seconded by Committee Member McMillan. All those in favor? Motion is carried. Okay. Thank you very much. The next item of business is PL 2023-11, the validation certificate, Garfinkel Biderman LLP. The recommendation is that the Committee of Adjustment of the Township of Georgian Bluffs approve the issuance of a certificate of validation for lands described as PIN 37020-0327, Part Lot A, Georgian Range, Keppel, PT. Is that, what is that? Is that part lot? Okay. Part lot 15, Road 66, or what is the RD? Road 66. I don't understand all these acronyms, so I'm just gonna say them. T-W R521476, Georgian Bluffs, Wyerton, and PIN 37020-029, Part Lot 43, Colpoys Range, Keppel, Part Lot 11, Road 70, T-W R530118, Georgian Bluffs. I'm going to ask for a mover and a seconder. Moved by Committee Member Ladresse, seconded by Committee Member McMillan. Is there any discussion? Would you like to present anything on that? I didn't ask for any comments, sorry.
Mr. Chair, I'd like to invite Wendy Greenspoon Sower of Garfinkel Biderman to make the application to the committee.
Thank you.
Good afternoon. Thank you for having me today. I think the report of Ms. Burnett set out succinctly and probably all the details that you would require. This is an application to validate a title transfer that took place previously, whereby the transfer would otherwise be void under the provisions of the Planning Act. The three lots in question, two of them were purchased in 2017, but the vendor who conveyed title retained the fee in the adjoining roadway, and that's why it was in contravention. As the report recommended, this will not change the status of the lots. They won't become buildable or developable because of it. It will merely validate the title transfer that previously took place that would otherwise be void. And it does so retroactively. And unless there are separate pins, there are separate assessment rule numbers. It's on a private roadway. And unless there's specific question that the committee would like me to address, we ask that they be granted.
All right, looking to the committee members, any questions or comments? Oh, Committee Member Glenn.
So this is a question more for clarification as the first part, and then I probably have a series after that. So as I understand the application, the two properties that were transferred and sold had merged with the retained piece some time ago. So no different than was just here. The properties all merged together. And as I understand, if that's the understanding of it, Section 57 under the Planning Act is to deal with errors in the act, not an issue with title. So I'm going to request, Mr. Chairman, this application be deferred and that the township solicitor be requested to review and to see if Section 57 is the appropriate tool to deal with this matter.
Okay. Any comments by other committee members? Madam Secretary Treasurer, do you want to weigh in?
No, thank you, Mr. Chair.
So I think we've moved the recommendation. So I think could we look for the mover and seconder to withdraw the motion, or should we could defeat the motion, or we could suggest an amendment?
Through you, Mr. Chair, I believe an amendment would be appropriate, given that Member Glenn has put one on the floor to A, defer the application, and B, to direct the Secretary Treasurer / Senior Planner to engage with legal counsel on this file. You just need a mover and seconder for that.
So would we move an amendment to this motion?
Yes,
What would we do with the original motion? What would we do?
So what happens is, so you have this motion on the floor now. So you'll just need to have a proposed amendment on the floor with a mover and seconder. Then what happens is you vote on the amendment,
Yep.
and then you draw your attention back to the main motion, and the main motion becomes the amendment.
Okay.
Yes.
So we won't defeat the initial motion. It'll actually be the amended
It
version
will
of
just be
Thank you.
amended. Yes.
Okay.
Correct.
Okay. So I think, do you want some wording? I think oh, sorry. Yes, you have a comment, Wendy?
Yes, I just wanted to address the concern that this is being used improperly to correct a title error. The transfer of the properties, if it had been done with a request for a consent, then you would consider certain factors. And in this instance, a number of them were presented. The fact that these are separately treated parcels with separate pins, with separate taxes, there's not an attempt here to sever a lot without getting consent and then retroactively validating it. There's not going to be building on these lots. If you saw in the diagram, they were far and separate apart. So the considerations that would normally have been taken into consideration have been taken into consideration in, I would have submit in the report that was presented that addressed one of the very purposes of the validation certificate, which is to determine if it's in keeping with what's intended or if it offends in any way. And in this instance, it doesn't. It's just, I'm just a solicitor, but in my experience, this validation certificate has been used for this purpose before in consultation with Mr. Sidney Troyster, who's a Toronto lawyer who's written many books on Planning Act and expertise on it. I actually consulted with him, and it was his recommendation that we apply for a validation certificate. So I would ask for some reconsideration of the motion that's being amended on those grounds.
Thank you. Any comments from committee members?
Through you, Mr. Chairman, in all my years in working in municipal government, this is the first time I've ever seen Section 57 used to deal with lands that had merged through the Planning Act. And so I would like a legal opinion to the municipality to inform committee on the decision.
Yeah. Secretary Treasurer?
Just as a point of clarification, the validation certificate isn't dealing with the lands that have merged. The certificate is dealing with the title. So if you look at the documentation, like the law of subdivision control by Sidney Troyster, It speaks to the fact that it is a tool to correct a mistake that a lawyer has made in transferring the land. So when they looked at the parcels that were for sale, they didn't verify that the seller did not own adjacent lands or adjoining lands, which was the case here. So the purpose of the tool is to correct the title, not to enact a consent of the property.
Committee member Ladresse. Oh, sorry, no, you guys are blurry on the screen, way far away from me. You still have your hand up?
I do have a question though.
Okay.
To you, Mr. Chair. Jennifer, the senior planner, would you do anything differently to correct this issue if a deferral was requested?
Through your chair, one of the reasons why the validation certificate is coming forward is because of the type of error that was made. If this application came forward as a consent, it wouldn't meet the Planning Act requirements for a consent. Without having a number of studies done. So they would require an environmental impact study, slope stability, and so it's a different tool to be used. So it's not that something different that I would do something different. It's the validation certificate merely validates the title and recognizes the transfer or the conveyance of the title to that property.
All right, thank you. I'm just going to make a comment here. The report was submitted with staff approval. I don't see why we can't support it, but we'll see what the other committee members say. Thanks.
Okay, thank you. Mrs. Greenspan, you have your hand up again? Yep.
Yes, and again, I thank you, Ms. Burnett. I think just to highlight on that one issue of the error, because the lots were not abutting the two lots that were actually purchased, it is the kind of error that was made because it was the roadway where it abuts. If you again look at the diagram, they're far and separate apart, the two lots, and so that's why it was missed.
Okay, thank you. I think if there are no comments, then we have a proposed amendment on the floor to seek a legal opinion before we approve this. So I would need a seconder for that amendment. Okay. So failing a seconder for that motion, then I think we have the original motion on the floor that we need to vote upon. So would committee like me to reread that? Thinking yes, but we talked for a long time. I'll just go ahead and read it. Our recommendation is that the Committee of Adjustment of the Township of Georgian Bluffs approve the issuance of a certificate of validation for lands described as PIN 37020-0327, Part Lot A, Georgian Range Keppel. It strikes me that I shouldn't have agreed to read this again because I hated it the first time. Part Lot 15, Road 66, TWR521476, Georgian Bluffs, Wyerton, and PIN 37020-0299, Part Lot 43, Colpoys Range, Keppel, Part Lot 11, Road 70, TWR530118, Georgian Bluffs. We have a mover and a seconder, so I'll call the vote. All those in favor? All those opposed? That motion is carried. Thank you very much. Our next item of business is PL 2023-20, the minor variance report A-12-22 for Terry and Tracy Fairbairn. Sorry. This is a meeting of the Committee of Adjustment to consider the application for a minor variance for Tracy and Terry Fairburn under Section 45 of the Planning Act regarding property located at unassigned Grey Road 1. Madam Secretary Treasurer, please go ahead with your review.
Thank you, Mr. Chair. There have been no requests for deferral or withdrawal of the application. Notice of this minor variance hearing in accordance with Ontario Regulation 296 made under the Planning Act was given on January 18th, 2023 by ordinary mail to all property owners within 60 meters of the property, which is subject to the application and to all the required agencies. Notice was also posted on the subject lands in the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the committee. Only a person or public body that requests a notice of decision of the committee in respect to this proposed minor variance may submit an appeal. Mr. Chair, I would like to state that additional comments were provided by the applicant from Saugeen Ojibwe Nation, reiterating that they are satisfied with the requirement for an archaeological assessment being made as a condition of approval of the application. Staff recommend that given this comment from SON, the staff are recommending that the application be approved.
Thank you. Tracy Fairburn, please introduce your application. Yep, that's okay. That's fine. Sorry, I'm just either or. You can both go.
We're one and the same, really.
Very good.
Thank you for this evening. We're here today to support minor variance application and explain our proposal. Our intention is to build a permanent residence on our lot, which is a normal and permitted use in a shoreline residential area. We require relief from the 23-meter setback from the center line of the road to a 19-meter setback, as well as relief from the 15-meter setback at the rear of the building envelope in order to build a family home. Please know that we have taken great care and consideration when designing our house, working with interesting topography and keeping a narrow footprint to keep our house a 6 meter away from the toe of the slope. In summary, the proposal is consistent with the policies of the official plan and generally meets the intent of the bylaw, and no negative impact to the environment would be assessed. Basically, it's a very steep lot. About 95% of the lot is unbuildable. There's really only a small envelope at the front. With these variances, we feel like we can build a nice house. Thank you.
Thank you. So no one is registered with the clerk to provide comments in support or in opposition of the application. Does the committee have any questions? Okay. So when I looked at this, Madam Secretary Treasurer, where specific words here. The minimum setback is the sticking point for this, is that right?
So the application is a reduction in the setback to the center line of Grey Road 1 from 23 meters to 19 meters, as well as a reduction in the setback from the environmental protection zone. So it was reviewed by the Conservation Authority. The required is 15, and they are prepared to support 0 meters.
Okay. So I'll read the recommendation if there's no questions and comments. The recommendation is that it cannot be determined that application A-12-22 for Terry and Tracy Fairburn to request relief from zoning bylaw 2020-20 to reduce the minimum setback required from the center line of Grey Road 1 from 23 meters to 19 meters, and to reduce the minimum setback required from land zone environmental protection satisfies the 4 tests of a minor variance as required by the Planning Act, RSO 1990, paragraph 13. It is recommended that the decision on application A1222 be deferred pending the submission of an archaeological assessment to the satisfaction of the township and the Saugeen Ojibwe Nation. So yep.
Just with the update with SON, I believe that, oh, sorry. Oh, okay. Okay.
I think we're not quite there yet.
Okay.
I think if you let me keep going, you'll be happy. Sorry, I'm a bit informal, so I was happy to let you ask the question. Yeah. So in consideration for the additional comments from SON, recommendation has been changed. So I'm going to allow the Secretary Treasurer to read the amended recommendation.
Sorry, just one procedural matter, if I could. The reason that this recommendation is being read out is because it has to receive a disposition of the committee because it was advertised on the agenda. So we still need a mover and seconder to put this recommendation on the floor, and then we can consider an amendment to approve the application as per the recommendation, the updated recommendation of the Secretary Treasurer Planner.
Okay. So before we go any further, is that clear to people? Is that clear to committee members? Okay.
I just one quick question for you, Mr. Chair. So we're going to propose to put this on the floor and then we'll go with the recommendation for approval after?
So we're going to put this on the floor. We're not going to vote on it. And we're going to have the Secretary Treasurer read out the amended recommendation. Is that correct?
Okay.
That was a question. Okay. So
Thank you.
I'm going to ask for a mover and a seconder to put it on the floor first. Moved by Committee Member Glenn, seconded by Committee Member McMillan. So I'm going to ask the Secretary Treasurer to read the amended recommendation.
Thank you, Mr. Chair. Application A1222 for Terry and Tracy Fairbairn to request relief from zoning bylaw 2020-020 to reduce the minimum setback required from the center line of Grey Road 1 from 23 meters to 19 meters, and to reduce the minimum setback required from land zoned environmental protection from 15 meters to 0 meters, satisfies the 4 tests of a minor variance as required by the Planning Act. It is recommended that application A1222 be approved, subject to the conditions noted herein. 1, that the owners shall undertake a Phase 1 and a Phase 2 archaeological assessment prior to any development or site alteration on the subject lands, and implement any mitigation measures identified to the satisfaction of Saugeen Ojibwe Nation and the township. 2, that the owners shall apply for and receive a permit from the Grey Sauble Conservation Authority prior to any development or site alteration on the subject lands, in accordance with Ontario Regulation 15106, Regulation of Development, Interference with Wetlands and Alterations to Shoreline and Watercourses.
Okay. I'm going to ask for a mover and a seconder, but then I'm going to ask for clarification because I think now and then we'll have 2 motions on the floor.
Okay, through you, Mr. Chair. So the reason that the existing motion, so the main motion as presented by Jen originally in the report, so we have put that on the floor because it was advertised on the agenda. So what we're doing now is amending that motion for it to be approved. I recognize that it looks significantly different. However, best practice is to give recognition to the recommendation that was published on the public agenda.
So I'm going to ask for a mover and a seconder for the amended motion. Mover, Committee Member Ladresse, seconded by Committee Member McMillan. Is there any further discussion? Seeing none, I'm going to call for a vote. All those in favor of the amended motion? All right, that motion is carried. Do I still need to read the original motion?
Through you, Mr. Chair. So that amendment has now become the main motion.
Okay.
So now you need to take the vote on the main motion as amended.
Okay. Now I'll ask for a mover, or we have a mover and a secondary, so I'm going to call for a vote on the original motion as amended. All those in favor? That motion is carried. Thank you. It's okay. So I'm going to call for an adjournment of this hearing. All those, a mover and a seconder. Moved by Committee Member Ladresse, seconded by Committee Member McMillan. All those in favor? That motion is carried. This public hearing is now adjourned. Sorry for that extra stress. That's free, though. You don't pay extra for that. That's just free. So we have one item of unfinished business, item 7.1, PL 2023-09, addendum to PL 2023-07 for A-11-22 for Keith and Kathy Fleming. The recommendation is the minor variance application A-11-22 for lands described as Plan 557, Lot 6 Keppel, seeks to increase the total lot coverage in the shoreline residential zone from 15 to 25 to permit a detached dwelling to be built that satisfies the four tests of a minor variance as required by the Planning Act, RSO 1990, paragraph 13. It is recommended that application A-11-22 be approved, subject to the conditions outlined herein. Secretary Treasurer, do you want to offer some comments?
Thank you, Mr. Chair. So this application comes back before the committee. It was presented last month at the January 17th meeting, and the committee was looking for some clarification on a few items of the proposed development. So that included the dwelling unit size, the slope stability requirements, and the shared driveway. So within this addendum report, there is clarification here that the requested lot coverage increase to 25% will accommodate the detached dwelling with the attached deck. And there's some calculations presented there for the committee's consideration. Because when we do the calculations, it comes out to 24.1%. What we tend to do is round up to the next whole number, and that effectively allows for any margin of error at the design or building stage. It's something in the past that we've come across where the applicant has requested a minor variance for lot coverage, and ended up being a percentage point out over actually in their building. So they went through the whole process of a minor variance application and, for example, requested 24% lot coverage, but actually came out to 24.3% and had to reapply. So what we tend to do is, recognizing that applicants are not, the application can't always be specific, we allow for that margin of error by rounding up. So that rounding up really just results in an additional 150 square feet of building area on the property. In terms of slope stability, we revisited the Conservation Authority comments. They're not requiring a slope stability assessment to support the application. They're requiring it at the building permit stage. The property is entirely regulated by the Conservation Authority, so their permitting process will address the slope stability issues when the final designs have been created, as well as the lot grading. The lot grading and drainage plans are technically finalized. So their interaction with the geotechnical engineer during that stage will also involve the building department. The other issue was the shared driveway, and the The shared driveway, the permits for both of those properties were issued by the county. The county supports the shared driveway. Their comments on the application it did not voice any objection to the continued use of this access. So in our zoning bylaw, there is a provision that that allows a non-conforming use to continue, and because it's not further contravening the provisions of the bylaw. So there's no changes proposed to the access. There's no changes proposed to the location of the driveway through the application. So there's no mechanism to change any of the entrance permissions for the property.
Okay, I'll look to the committee members for comments, questions. So I know in planning brain, I know you hate these questions, but basically when it comes to this slope stability question, what we're saying is yes, still, just not yet. It's part of the building permit process, not part of the process we're undergoing right now.
That's correct. So the one of the conditions in the decision would include that the owner provides a letter of opinion from a qualified geotechnical engineer to support the siting of the proposed dwelling within that oversteepened slope to ensure slope stability.
Okay.
So it's one of those things where the engineer is going to go and do the assessment at the time of the building, be on site. It's not procedurally, it's not something that the engineer in this situation would go out and conduct an analysis at this time without any other development going on. So I believe that if the slope was at a certain grade, the Conservation Authority would require that prior to the application being approved to demonstrate that that lot could be developed.
All right, I'm going to ask for a mover and a seconder. Moved by committee member McMillan, seconded by, excuse me, committee member Ladresse. I'm going to call the vote if there's no discussion. All those in favor? Opposed to Finney? Okay, that motion is carried. So our next item on the agenda is the date and time of our next regular meeting. The Committee of Adjustment will meet as regularly scheduled on March 21st, 2023. I'm going to ask for a mover and a seconder for adjournment of the meeting. Moved by committee member Glenn, seconded by committee member Ladresse. Call the vote. All those in favor? That motion is carried. We are now adjourned. Thanks very much, committee members and staff.